Hello aspirants, welcome back to Where IAS. In our video lectures on Indian polity, we were studying about fundamental rights. So in fundamental rights, it is important to study all these 6 topics. We had already covered in detail all these 5 topics and we had started with the 6th topic, that is classification of fundamental rights. So in classification of fundamental rights, we studied that there are 6 fundamental rights. And we had already covered the 5 fundamental rights in detail, that is the right to equality, right to freedom, right against exploitation, right to freedom of religion, the cultural and educational rights were already covered in our previous video lectures. Now, we shall start with the last fundamental right, that is right to constitutional remedies under Article 32. So here, right to constitutional remedies. So what is this remedy? We seek remedy when there is some threat, right? We seek solution when there is a threat. Here, the threat is for fundamental rights. That is, when there is threat or violation of the fundamental rights, then we can seek remedy or solution. This is what is the remedy for fundamental rights, that is Article 32 is giving with. So here, what is this remedy? This remedies or solutions is given in the form of writs. That is what Article 32 is saying. That is, see, if there is violation of fundamental rights, then the solution to it, that is the protection for the violation of fundamental rights, is itself given as a fundamental right under Article 32, right? So, this shows the significance of fundamental rights. That is, even for the violation of fundamental rights, there is a solution and that solution itself is a fundamental right, and that is what shows the significance of fundamental rights. And Dr. B.R. Ambedkar had called Article 32 of our Constitution as heart and soul of our Constitution, and this also shows the importance of this Article 32, that is the remedies for the violation of fundamental rights. So how to seek remedies? That is, where can we go to seek the remedies? So what Article 32 is telling us, to seek remedies one can directly go to Supreme Court. So then what about the cases with respect to the other courts? That is, Parliament can empower other courts to issue writs. So for now, the authority to issue writs is given for Supreme Courts, whereas for the other courts, Parliament, here it is important to remember that the empowering authority with respect to the issuance of writs to other courts is Parliament. That is, Parliament can only empower the other courts to issue writs, but at present Article 32 is giving powers to Supreme Court to issue the writs for the violation of fundamental rights. So here Supreme Court can issue writs. What is the meaning of writs then? Writs is nothing but it is a written court order, and this writ jurisdiction was taken from Britain. So this is about the writs and the writ jurisdiction of Supreme Court. So if we see the writ jurisdiction of Supreme Court, I said that, so when there is a violation of fundamental rights, you can directly go to Supreme Court, right? So this is called as original jurisdiction of Supreme Court. That is, for the violation of fundamental rights, you can directly approach Supreme Courts to seek the remedies. And this is what is called as original jurisdiction. And the writ jurisdiction of Supreme Court is also original. That is, you can directly go to the Supreme Court. And you must know that the writ jurisdiction of Supreme Court is not exclusive, because High Court has also been given with the powers of writ jurisdiction. So, both Supreme Court and High Court has got the writ jurisdiction powers, and hence Supreme Court, the writ jurisdiction of Supreme Court is not exclusive, but it is original. Then what is the difference between the writ jurisdiction of Supreme Court and High Court? This is to be noted. Here, writ jurisdiction of Supreme Court is given under Article 32, whereas the writ jurisdiction of High Court is given under Article 226 of our Constitution. I said, for the violation of fundamental rights, we can go to Supreme Court and seek the remedies, right? So here, the writ jurisdiction of Supreme Court is only used when there is a violation of fundamental rights. So it is, the writ jurisdiction of Supreme Court is limited only with respect to the violation of fundamental rights, whereas the writ jurisdiction of High Courts is for all legal rights. So what is the meaning of legal rights here? Legal rights, that is, which have the backing of law. So it includes both the constitutional rights and also the other statutory rights. That is, the rights that are covered under the ordinary laws are also included under legal rights. So if there is any violation of these rights, of these legal rights, then we can go to High Court and seek the remedies. So the writ jurisdiction of High Court covers all the legal rights also, whereas the writ jurisdiction of Supreme Court is limited only with respect to the High Courts. So here the writ jurisdiction of High Court, we can say it is broad when compared to the Supreme Court. And also I said we can go to Supreme Court to seek the remedies, right? And also the Supreme Court is bound to accept it. So whereas High Court may or may not accept the case, here the Supreme Court is bound to accept the case of violation of fundamental rights and Supreme Court has to issue the writs. So here Supreme Court is considered as the guardian or the custodian for the protection of fundamental rights, and hence Supreme Court has to accept this case of violation of fundamental rights and issue the writs, whereas High Court may or may not accept the writ jurisdiction. So this is about the difference between the writ jurisdiction of Supreme Court and High Court. Then what are the types of writs? So here the Constitution mentions or provides for 5 writs. The first one is habeas corpus, second is mandamus, and third writ we have is certiorari, fourth is prohibition, and fifth is quo warranto. This list has to be remembered. That is, the first we have is, first writ is habeas corpus, second is mandamus, third is certiorari, fourth is prohibition, and fifth is quo warranto. So here very simple, that is, if there is a violation of fundamental rights, you can go to Supreme Court and seek the remedies, and this, that is, you can directly go to Supreme Court, right? So this is called as original jurisdiction, whereas High Court is also having the powers to issue the writs. Hence this is not exclusive to Supreme Court, because High Court is also having the powers to issue the writs. Then what is the difference between the writ jurisdiction of Supreme Court and High Court? The difference has to be noted. And also one more thing it is to be understood here is, Parliament can empower other courts also to issue the writs. So who can empower? That is Parliament, right? This is to be remembered. And also we must remember the list of writs. Let's study about the meaning of each writ in our future video lectures. For more videos, keep watching VAR IAS, and also please share, subscribe VAR IAS. Thank you.